Welcome everyone to this talk by Three Paper Buildings Chambers on an introduction to judicial review. My name's Matthew Wyard. I'm a specialist public law barrister at Three Paper Buildings, albeit my particular area of interest is education, health, social care, with a little bit of planning on the side. I'm joined today by my colleague Jim Hirschmann, who will introduce himself shortly. But before he does, let me run you through the agenda for today. These are the 7 things that Jim and I will be talking to you about. Firstly, the purpose of judicial review and what it's all for. Secondly, what kind of decisions are amenable to judicial review. Thirdly, who can bring a judicial review. Fourthly, the procedure that's followed. Fifthly, the grounds of challenge for judicial review. And lastly, remedy and costs. Without further ado then, I'll hand you over to my colleague Jim Hirschmann, who's going to talk to you about the purpose of judicial review.
Hi, as Matt kindly said, my name's Jim Hirschmann. I'm also a public law barrister. Education, social care and family are my main areas, but ancillary areas of public law challenge are very much areas I'm interested in and practice in. So the first subject today is the purpose of judicial review. And what you'll see, hopefully on this slide, is D. Smith's definition of it. But the way that I like to think about judicial review is it's a way that citizens and that society can make sure that public power is used in the way that was intended. So let's just break down D. Smith's definition. We live in a society that has a set of legal standards that can be enforced through a process of litigation. That means if a public body or the exercise of public authority is considered by a member of the public to be unlawful, it can be challenged. And that, at its core, is a point of judicial review. It's the system of rules that allow us to bring those challenges. So I'm sure you'll all appreciate, very important, and that's why you're at this talk. But we're going to go on now. I'm going to pass back to Matt to talk about standing and who it is that can bring a judicial review claim.
Thanks very much, Jim. What decisions then are amenable to judicial review? Well, as Jim has suggested to you, it's decisions made by public bodies, such as traditional public bodies, local authorities, clinical commissioning groups, universities, schools, etc., but also bodies that exercise public functions more widely. One such example would be an independent school where it exercises public functions by accommodating a child under Section 20 of the Children Act, for instance. Now, one thing that's extremely important for judicial review claims is pinpointing when the decision to be challenged is made. And the reason that's important is twofold. Firstly, because time limits in judicial reviews are extremely fast, and we'll come on to talk about that later. And secondly, because judicial reviews, unlike some civil claims, have a habit of rolling on. The interaction between the individual and the state doesn't stop just because you're at the door of the court. You need to make sure that you pinpoint the decision that you're challenging so that you don't get lost in the ever-developing factual matrix of the claim. The last point on the slide there is an important one, which is what about when public bodies exercise private law functions? In that scenario, you can't challenge the judicial, the public body when they're exercising a specific private law function. You can't do it by the way of judicial review. That was my brief spiel on amenable decisions. Jim's now going to talk to you about standing.
Thank you, Matt. So Matt's explained that where there's amenable challenge to judicial review, it can be brought. It begs the question, who can bring it? Well, the Senior Courts Act makes clear that to bring the claim, the claimant must have sufficient interest in the matter to which the application relates. And what that means in practice, there's two cases there that illustrate it, is essentially a wide range of factors. The duties in question, the nature of the alleged breach. The real question is, does it affect the person seeking to challenge it? So mere busybodies are not able to bring a judicial review claim, but if a decision directly affects you, there's a good chance that you or your client will have standing to bring the claim. It's really, really important that one acknowledges that standing goes to the heart of the court's jurisdiction. If someone doesn't have standing, they can't bring the claim, and the court can't exercise its jurisdiction. It's therefore really important that you make sure you or your client have standing before you embark on a judicial review claim. There's one exception, which is in the context of environmental claims. The test set out in Walton and Scottish Ministers shows that a genuine interest in the aspects of the environment that they seek to protect is the test. And as you can see there, that might go more broadly than anyone directly affected. It seems to be a much broader test, and that might become much more of a point of litigation as environmental law and environmental law challenges becomes an ever more present part of the society in which we live. I'm going to hand over now to Matt to consider limitation.
Thank you very much, Jim. Moving on then to procedure. Judicial review, unlike other areas of civil law, has quite a specific and unique procedure. And there are various pitfalls one needs to be aware of when litigating this type of claim. The first point is limitation. Unlike a breach of contract claim where you have 6 years or forever and a day, seemingly sometimes, to bring a claim, judicial reviews are much, much quicker. You, by way of CPR Part 54, in particular 54.51, must file your claim promptly and in any event not later than 3 months after the grounds to make the claim first arose. The key word there is promptly, because by way of section 31(6) of the Senior Courts Act, even if the claimant brings a claim within 3 months, if it hasn't acted promptly, the court may refuse to grant permission if there's been a delay. So it's important that you don't just sit on your laurels when a cause of action arises and wait the full 3 months. You need to bring the claim quickly. That being said, absolute limitation will be taken to be 3 months, less 1 day from when the decision was taken. And as I've noted on the slides there, as in some other areas of civil law, 54.52 of the civil procedure rules provides that limitation can't be extended by agreement between the parties. Now, 3 months promptly, and in any event 3 months, is the default for most types of claims. It's worth bearing in mind, if you are doing this kind of work, that some types of judicial review challenges have far quicker limitation periods, particularly planning. 54.55 of the CPR provides that decisions made by local planning authorities or the Secretary of State for Levelling Up need to be brought within 6 weeks. Procurement challenges, it's 30 days, and in some judicial review challenges in the upper tribunal, there are also additional limitation periods. The overriding point to take away really is to make sure that you check. We've dealt with limitation. The other unusual aspect of procedure with judicial review claims is the concept of remedy of last resort. Judicial review is considered a remedy of last resort, and you need to be aware, if you're acting for claimants or defendants, that a judicial review claim cannot be brought until all of the other alternative remedies have been exhausted first. In particular, suitable alternative remedies. And again, there's a slight difference between whether there are other alternative remedies available and whether they are suitable for the purposes with which the claimant requires relief. There are judicial alternatives that can be considered acceptable alternative remedies, the most obvious one being the ombudsman schemes that are available in higher education and local government law generally. And you can get into arguments in judicial review claims about whether or not those ombudsmans are a suitable alternative remedy, particularly given the timescales that some of complaints to such bodies can take. But ultimately, the point to bear in mind is that if a claimant has a suitable alternative remedy available to them, they are unlikely to be able to bring judicial review proceedings. There are, as with any legal rule, some exceptional circumstances when that doesn't apply. They have to be relatively exceptional, and it's happened very infrequently. The best example that I could find, and I'm not going to go through the case now in any detail, is the one that you can see on your screen, the King, or the Queen as it was at the time, on the application of MRH solicitors in Manchester County Court. That is one of the very few examples where, in spite of there being an alternative remedy available to the claimant, the court exercised its discretion to allow a judicial review claim to be brought. With those two key procedural points out of the way, what actually is the basic procedure for bringing a judicial review claim? As with any civil procedure, the first step is to engage with a pre-action process. For judicial review purposes, that's outlined in the pre-action protocol for judicial review. The protocol effectively provides that a letter before claim needs to be sent, outlining various factors that are specified within the pre-action protocol. And indeed, Annex A of the protocol, there's a very, very helpful precedent that one might want to use when preparing such a letter. Once the letter before claim has been sent, typically the defendant or proposed defendant is entitled to 14 days within which to respond, and then they have to send a letter of response. Again, there is a template letter of response found in Annex B of the pre-action protocol. Once you've received your letter of response, or if you're a defendant and you've received a letter before claim, what you need to be doing relatively quickly, because you don't have very long, 14 days, if you're a defendant, and potentially not that much longer once you've got a letter of response if you're a claimant, is analyse the merits of the case quickly, and particularly if you're a claimant, make any necessary funding applications, for instance, applications for legal aid. Once you've analysed the merits of your claim, and you're either ready to issue or ready to defend the claim, then the claimant needs to prepare their claim, issue it in the court, and serve it upon the defendant, filing a certificate of service within 7 days of service. After that, the defendant has a brief period of time to file an acknowledgement of service alongside summary grounds of resistance. They are, as the name might suggest, generally relatively brief, and they typically only address any real fundamental problems with the claimant's challenge. It's not the defendant's opportunity to rehearse the entire defence of the claim. Typically, in my experience, the most effective types of summary grounds deal with key procedural points that can stop the claim dead. Once the claimant's claim and the defendant's summary grounds are received, the court then considers the matter on the papers and determines whether to grant the claimant permission to bring its claim. The test that the court applies is whether there are arguable errors of law in the decision that the claimant seeks to challenge. There are 3 options available to the court on a permission decision. The first is to allow permission. The second 2 relate to refusal of permission. Permission can be refused on 2 bases. One, a straightforward refusal, and secondly, a refusal with a certification that the claim is totally without merit. The fundamental difference between those 2 types of refusal is this, that if the claim is only refused permission, the claimant can then request the permission decision is reconsidered orally at a hearing. If the claim is dismissed as being totally without merit, that can't happen, and the route of appeal is to the Court of Appeal. Assuming, however, that you're successful in your application and permission is granted, the defendant then has 35 days to file and serve detailed grounds of resistance and any evidence that they wish to rely on. And you'll notice, of course, the difference between detailed grounds of resistance as compared to summary grounds of resistance, and you can probably guess that detailed grounds of resistance, as one might expect, have to answer the entire claim put forward by the claimant. The claimant, interestingly enough, doesn't really need to procedurally do anything. They simply need to wait for the defendant's grounds of resistance. Once that's done, various steps are outlined in the CPR, as you would expect to prepare for any type of hearing, really. Skeleton arguments, lists of issues need to be drawn up, and a bundle prepared. One other aspect of judicial review procedure that is worth considering is urgency. Judicial review, in many contexts, is used as an extremely effective way to have a court make a decision quickly. However, over the years, that process has been, according to the court, perhaps abused is the right word, more than it should have been, which has led the court to take a more militant view on when claims should be being brought by way of urgent consideration. My general view is that it's best to avoid bringing a claim by way of urgent consideration unless, as I've suggested on the slide, there's some irreversible detriment to be suffered by the claimant, unless the entire claim from start to finish needs to be resolved within a week. What's important when you think about urgency is that you think about it from the judge's perspective. To you and your client, something may be urgent. Some of the types of challenges that are sometimes considered urgent are things like a child not having school transport, or in the context of adult social care, a care plan not being issued within the statutory timescales. They, in reality, to a High Court judge that's used to hearing claims about people being deported and are potentially at risk of torture, or some High Court judges hear end-of-life treatment cases, albeit not in the judicial review context. Claims like school transport are probably not going to be considered urgent in the context of the work of the admin court as a whole. And that is what you need to think about when you consider if your claim is urgent, as well, of course, as the facts of your case. There will be cases that don't immediately strike you as urgent, but where there is an interesting factual point that needs to be disputed quickly. One big point to bear in mind is that it's extremely tricky for you if you get it wrong. The court has what's called the hammered jurisdiction, where if it considers a claimant has used the urgent consideration process improperly, it can haul the advisors before the court to explain themselves at the risk of referral to their professional regulators. My view generally is take advice. If you are considering using an urgent consideration process, speak to counsel, get some advice on counsel's view as to whether it's urgent, because the chances are they may be in a better position to advise that than you. You can seek interim relief by way of judicial review. Interim relief typically takes the form of an injunction, and the injunction will be dealt with in the usual way on the well-known American cyanamid principles, with one difference, which is that the court bears in mind the fact that the defendant's a public body. So, for instance, things like cross undertakings and damages aren't so readily required. Something that you will hear about when you start undertaking judicial review work is the duty of candour. That applies to both parties from pre-action throughout the proceedings. I've given you two quotes on the screen, one from the Queen on the application of pork fishing and the Secretary of State for Foreign and Commonwealth Affairs, and then the well-known quote from Bankholt and the Secretary of State for the Commonwealth that explains in a bit more detail what the duty of candour is. Effectively, it's an additional burden on the parties to present their case with complete frankness and complete fullness of the facts, including, as you can see from Bankholt, where facts or evidence may assist with an as unyet pleaded claim. So lastly then, before I hand back over to Jim to talk to you about the kinds of grounds that you might want to bring a judicial review claim on, what are my practical points to consider? when bringing a judicial review claim? Well, there are 6 on the screen. Going through each of them in turn. Firstly, once you've received the defendant's detailed grounds of resistance, if you're a claimant, you don't have, under the CPR, a right of reply. And if you stick strictly to the CPR rules, you won't put in a reply. In practice, 90% of judicial review claims, a claimant will put in a reply to the defendant's detailed grounds of resistance, and the court will typically consider it as long as it's in good time before the permission decision is made. I have known cases where after the claimant's reply has gone in, the defendant then puts in a response to the reply. I would suggest that you don't want to keep going back and forth between the parties, because it's going to serve no purpose and to irritate the court. But if there is something that you really need to say, you shouldn't be scared of putting an additional document in. Point number 2, admin court judges deal with a wide range of cases. Some of them will have particular expertise that the others don't. For instance, education is one that jumps out at me. If you think that your case is complex or the facts warrant it and you need a judge with a particular expertise, don't be afraid to ask for it. Thirdly, and this perhaps reflects another point that's not on the slide, is that you need to constantly be thinking when you receive detailed grounds of resistance, replies, responses, more evidence about the merits of your claim. You need to consider whether what you've pleaded remains relevant, or if certain facts have overtaken the claim and it needs to be repleaded. You can typically widen or limit the scope of your judicial review throughout the lifespan of it, and it's important that you bear that in mind whenever you're considering documentation. Fourthly, perhaps an obvious point, think about what further evidence needs to be filed all the way through your claim, particularly after you've received the other side's pleadings. Fifthly, and I'll deal with the last bullet point first, oral evidence. Typically in judicial review, it's a submission-based hearing, so counsel for the claimant and defendant will stand up, make their submissions as to why they should or should not, whatever the case may be, succeed in their application. The judge won't hear, as you might expect within a civil claim, oral evidence. That's not to say that the court can't, and the admin court can hear oral evidence if it needs to. Just make sure that you make the application to have oral evidence as soon as possible. Lastly, but fifthly on the slide, is the concept of a rolled-up hearing. If your judicial review is typically relatively urgent, but not urgent enough to warrant urgent consideration, you can request a rolled-up hearing, which is where the court considers permission and the substantive merits of the claim in one. The way it works in practice is you effectively turn up to the court and present your judicial review claim as though you've got permission. The court then deals with the permission point administratively within the decision. Those are my top practical tips. I'm now going to pass back over to Jim, who's going to talk to you about the grounds of challenge.
Thank you very much, Matt. Grounds of challenge. What are the bases on which you can get home on your judicial review and then seek an order for the remedy that your client or you want? Well, the traditional challenges come from the case of Council of Civil Service Unions and Minister for the Civil Service. They are often referred to as the Diplock grounds after the judge who set them out. And they are 3 main ones: illegality, irrationality, and procedural impropriety. I'm going to go through those in turn. So if we start with illegality, outside of the powers of the decision maker, ultra vires, there's several subheadings to that. First, you often get public bodies, public authorities making a mistake as to what their powers are, a mistake in law. An example of that in a recent case of mine was that a local authority thought that they could delegate one of their responsibilities to a school and tried to assert that they were not in breach of their duty to provide special educational needs provision. because the school had failed, that they hadn't. That wasn't in fact the case. It was a local authority duty that they had to discharge. It was a mistake in law, and as a consequence, a successful judicial review challenge could be brought on that basis. Third point on this slide is mistake in fact. Local authorities need to make decisions on the basis of the facts as they actually are. And if they've made a mistake as to fact, then they should correct that and make the decision on the correct factual footing. Connected to that is proper consideration of the relevant criteria. Often there's a statute which sets out the powers that a local authority has, for example, or a public body has. The statute often also makes provision for guidance to which the local authority or public body needs to have regard. And it is, in my experience, not uncommon to see relevant considerations that is listed in the guidance, for example, that simply hasn't been factored in by the public body that we're challenging. So making sure that the decision maker has considered everything that they should have done is often a very fertile ground for exploring a basis for challenge. Exercising a power for an improper purpose is somewhat connected to the mistake of law. There are purposes for which powers can be exercised, and just because a local authority has the power, it can't just use it for any purpose. It's got to be in connection with the power which was granted and the reasons why that power was granted. Last, unlawful delegation or fettering of discretion. A decision maker who has the power to do something, they should be the one making the decision, and it's important that they take that responsibility seriously and in fact make that choice. Irrationality or unreasonableness. You'll hear it referred to as Wednesbury unreasonableness. It's generally a very high bar, and the test is whether it's so unreasonable that no reasonable decision maker could have made the decision in question. So there are other ways that you can explore that ground. So irrelevant considerations, wholly unrelated to the issue at hand, might be a basis for getting home Wednesbury unreasonableness. An improper investigation, meaning that they weren't really abreast of the correct facts of the situation, or if it's a decision that's been made in bad faith or dishonestly, then you might get into a situation where the court would consider no reasonable decision maker would have made the decision, and therefore relief can be granted. The third head, the third diplomat ground, procedural impropriety. There are certain processes that we expect public bodies to follow. That includes an absence of bias. That includes providing adequate reasons. And it includes a procedurally fair process that is followed. If either of those elements are not apparent from the process that has led to a decision, again, there may well be a basis for challenge. A slightly rarer example is legitimate expectation. Where a public body explicitly or implicitly makes a promise to do something, or to do something in a certain way, and it breaks that promise, causing the claimant detriment, then you might be able to go to court and try to hold the public body to its promise. It's an important point of principle, but in practice it's relatively rare. Most public bodies are quite alive to this and are not in the habit of making promises outside of their powers. And that's why illegality tends to be a more fertile heading for challenge. One should be aware of other potential grounds. So the Human Rights Act gives rise to various rights, and public bodies need to act in a way that is compatible with those human rights. On one level, that's a straightforward illegality challenge. The law says you need to act in a way that's consistent with your human rights obligations. You haven't, therefore you've broken the law. But it could also be seen as a standalone area, because human rights litigation is legion, and it has a very specific jurisprudence that needs to be considered when bringing a claim, and sufficiently large, I think, to be a standalone ground in many ways. So you've got home on one of the grounds. What's the remedy? Is the challenge worth it? Well, the first thing that anyone needs to bear in mind is that remedies are discretionary. Even if one succeeds in a judicial review claim, the court is not obliged to give a remedy. In particular, if there's no substantial difference, then you might be in some difficulty in succeeding in your claim. So what that means is, if the judicial review was granted, the court agrees with you that there was some defect in decision making, but the court thinks that there'd be the same outcome if the decision was made again, there'd be no substantial difference if the matter was considered again, then it's unlikely that you'll be granted a remedy. Having said that, there are a powerful toolkit of remedies that the court is able to give. It can declare that certain behaviour was unlawful, for example. Perhaps most powerfully is the mandatory order, which requires the public body to do something. That's often the case where you assert, for example, that your client or you yourself are entitled to a certain service. It hasn't been provided for a period of time, and you've had to bring judicial review proceedings. That's the circumstance where you will want an order saying the local authority, the public body, must within 7 days, for example, do the certain action, put the facilities in place that it's obliged to. A prohibitory order prevents the public body from doing something. That might be particularly useful when you're perhaps in a planning case, environmental case, you don't want a certain development to take place, or there's a certain behaviour from a local authority or public body that you want to see stopped. There's a quashing order, which essentially renders the decision null and void. That can be a double-edged sword, because whilst the decision, the offending decision, is gone for the time being, it often means that the public body can make the decision again, and in some cases they will simply make the same decision but justify it without the defects, and they will come to the same view. Won't always be the case. Sometimes it's enough to get the local authority, the public body, to look at the issue again, and when they do and follow the correct procedure, it does lead to a different outcome. So it is powerful, but it's not guaranteed to lead to a different outcome. Last, but by no means least, damages. These can't be sought alone, but often follow from one of the other remedies. Moving on to costs. Bringing a judicial review claim can be expensive, and the general order that costs follow the event. That means typically, if you win the judicial review, then you will be able to recover the costs that you've expended in doing so. But the court, as with all matters of costs, has a wide discretion. You should be aware of costs capping orders, that legally aided parties benefit from a level of protection, and the interested parties and interveners are typically protected from cost risk, but are also in some difficulty when they seek to recover costs. I hope that's been helpful. That was a whistle-stop tour of judicial review. You can contact myself and Matt using the email address you'll see on this slide. But for my part, I'd say thank you very much for listening and for joining us for this talk.
Thanks, Jim. Thanks, everyone, for listening and joining the talk.